Hello, this is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. So I'm only focusing on questions tonight. We are hello on Instagram. Nice to see you all. Thanks for joining. I'm on a little later today. Put your questions in the comments so I can answer those questions. Now, in the meantime, I just want to talk about the T visa. So, lately we've been getting a lot of 4 year work permits. And as you know, hi there, Lucy. As you know, they have reduced for most work permits. They have reduced the time, the validity period of the cards to um, basically to 18 months. Hi there, Bruce. But the T visa work permit, they still have it at 4 years. So even though they get the work permit while they wait, it is 4 years. So if you qualify for this, then you would definitely get that. Well, you'd get the 4 year work permit unless, of course, they change it. That's why you need to jump and go. But you'd get the 4 year work permit, and while you're waiting for the final decision. So it's a very, very valuable form of relief that stabilizes families, individuals who really just want to find good jobs, have the safety and security. Now, what's the T visa and how can you qualify for it? So with the T visa, if you are in a situation, I usually state it very generally. So this is for victims of trafficking, but trafficking comes in many different forms. And some people think that the way that they're living is just a way of life for them as an immigrant. And because of that, they continue to tolerate exploitation, mistreatment, thinking that they have no rights. In this case, however, they may be the victim of trafficking and they don't even know it. So, what I often say is if you're in a situation where you're working for an employer or you're living with someone and they're forcing you to do things against your will. They're forcing you to do things that you would, and when I say against your will, they're not necessarily even holding you down or anything like that, but they're basically forcing you through their behaviors to comply with them, to do things that you normally wouldn't do. So, for example, if you agree to do certain types of work, and then you found when you got into the job, they're throwing all sorts of other things, they're making you do 10 different types of jobs. That is a classic example of exploitation that possibly could even be trafficking because you did not agree to do that. If they are taking your pay, so for example, we just had an appointment with someone who the entire time she worked, they were pulling taxes out of her pay. The thing is, she has to file her own taxes and pay her taxes because she's a contractor. But yet, this person convinced her that they have to pay it on her behalf. And that is a form of trafficking because they're forcing her into a situation to work and give part of her pay that she rightfully earned, they're taking it back. So they're really not paying her the amount that they agreed to pay. So that's trafficking by coercion and it's trafficking by fraud. But let us talk to you personally about what's going on in your situation and then determine whether you qualify, because qualifying and applying for relief could possibly mean that you could be one of those individuals that obtains a 4 year work permit and certain protections. You get the T visa as well. And once you get approved for the T visa, you're able to apply for the green card 3 years after. So it's a path to permanent residence. All right, now that I've said my spiel, I'm going to go ahead and answer questions. So Okay, so Arus, kindly talk about the new USCIS policy, which allows U visa recipients to adjust status based on a family-based petition. However, can someone with an approved I-360 adjust as the VAWA? So I don't know where this new policy is, but you cannot adjust as a U visa under a family-based category. The two don't mix, all right? And they certainly didn't change the law overnight to allow that to happen. So I don't know where you're getting that information from, but something seems a little twisted here because a U visa person can't adjust. A U visa, somebody who has had an approved U visa cannot then turn around and say, okay, I'm going to adjust on a family based petition. So there's something is missing here. Oh, thank you so much, Cat89. I really appreciate that. How could you qualify for an expedite for VAWA? So it's really based on a case by case basis. So if you are in an emergent situation, urgent situation, humanitarian crisis, that those could be ways to have the VAWA expedited. I'm a 20-year-old from India, and my friend's girl is in the US on citizenship. I want to move us. How she can be able to sponsor me, please? So your friend's girlfriend, and I think you mean okay, my girlfriend. You have to get married or do a fiance visa. If she's a U.S. citizen, you could do the fiance visa as well, or you could get married. You can always give us a call and we can talk. You'd probably have to do it through consular processing. Hi there, Nadia. Nice to see you. I'd like to know, please, why immigration is asking for a second interview for my husband. Is that to deport him? The lawyer can avoid that. Can avoid that on the interview. Great question, and you should definitely be talking to your attorney, and you should have a plan. Usually, this is a Stokes interview. So if they're calling you and your spouse in, or your spouse in for a second interview, be prepared for a Stokes interview. That means that they are now seriously evaluating whether there is fraud involved. And yes, in this day and age, detention could possibly be something that could happen. I don't know where you are, but one thing that commonly happens before detention during a marriage based process is the officer evaluating for fraud, then in their heads confirming that yes, they strongly suspect fraud, and so they detain at that point. So be prepared, talk to your lawyer, and make sure that you have a plan. And this is another example why it's important to have a lawyer going into this, because these cases should be simple, right? You get married to somebody, marriage is real, you just want to move on with your life, and then you end up in a nightmarish situation. Not saying that this is going to turn into a nightmarish situation. Hopefully, you go in, he goes in, and everything is fine. But it can easily, this is what's happening now. Simple cases are really escalating. And without an attorney to help you to navigate it, it becomes very difficult to come up with a plan or to correct a situation that may be brewing or escalating. If my spouse was separated 10 years ago but finally divorced last month, how long should she wait to get married again, especially if she's going to file an AOS for her spouse? So there are a number of questions that I would have here. Did she sponsor the first spouse, or did the first spouse sponsor her? So that would be the first question. Do you have a history with that spouse even before the previous spouse that could raise issues during the process? So, this definitely we have to sift through facts here, specific facts. So give us a call and let's sift through some of these facts to make sure uh, that we're strategizing properly and going into the process informed and ready and prepared, and you have everything. Yes, she sponsored the spouse. So I have represented clients who've been through previous sponsorships. I did, I even had a client who had sponsored two previous spouses before her third, and everything was fine. However, we are in a different time where those issues definitely raise red flags. So you want to prepare a solid application from the forefront. And then I just need to understand timing, and we need to look at timelines. When did she sponsor the spouse? So yep, she sponsored the spouse. What were the timelines? What was the process that they went through? Were there any red flags then that could possibly now come back up? So this is where we have to do an appointment for sure. So if not with us, make sure you're talking to an immigration attorney. If a pending U visa recipient is apprehended and deported by ICE despite having C-14, can they come back into the United States? So if they are deported, we'd have to look at the facts here, but if they were deported and it was we'd have to look at what happened. Did they sign documents saying that they are voluntarily going with them, or they will deport? Was there a court order? We'd have to determine what happened here. This may even require court action, going to federal court to come back into the United States. So they couldn't just come back, but you'd have to probably go to the court and show that somehow the removal was unlawful or it was by mistake, and that you should be allowed to come back into the US. So that's definitely going to be a federal court issue. All right, I'm looking for more questions. Put those questions in the comments. Unfortunately, the live is going on Facebook and YouTube, but I cannot see the comments. I can't see the comments, and this has been happening. This has been happening for the past 2 days. So I guess it's just gonna play and you can listen, but until I fix it, I don't know why this is happening. But sorry guys, on Facebook, YouTube, I can't see your comments, but hopefully by the time I'm ready to come back, I get this fixed. All right. I'm on TikTok now, so put your questions in the comments. I'm on TikTok. Thanks for the love. How to get an appeal from removal due to fraudulent application for VAWA never married. You need to talk to us because we have to understand what the facts are here. Hi, Nursepreneur. Nice to see you. Thanks for being a long-time watcher. Looking for questions on TikTok. Is there a pause for Afghan citizens applying for citizenship? Could you give some information? So I believe Afghanistan is on the banned country list, so there is a pause on the citizenship. And keep in mind now, everybody everybody is experiencing a pause or a delay right now, because if you're going through citizenship, they are now sending those applications back through FBI background checks. So everybody is going to be experiencing a delay of some kind right now. Thanks so much for the love. Um, we're at 3,000 likes on TikTok. Thank you for that. All right. Going through the comments, going through. Thanks so much, Sasha. It's nice to see you. Hi there, music lover. Nice to see you. What can I do if I file for my 10-year green card, but my lawyer's negligence is costing me my job? So you'd have to get a second opinion to see where the negligence was and what kind of damage. When it comes to negligence, that's a separate issue. You know, going after the lawyer or dealing with any negligence issues is a separate issue. But to get it corrected, get a second opinion from another immigration attorney. I filed VAWA after filing I-45. I sent conversion letter, which was delivered. And now you have an I-45 interview. Now, did you get your 360? If you got your I-360, make sure you have a copy of that letter again, because sometimes things get lost, sometimes it doesn't get to them on time. Have your abeyance letter, which I guess you're calling the conversion letter. Have your I-360 petition or proof that you filed your VAWA petition, and then provide it at the interview. While I'm not your attorney, I can't give you personalized legal advice. I would say it's not a good idea to just not show up. If you can successfully reschedule the interview or cancel it, uh, cancel it. So we have done that where, we've gotten interviews and we had enough time to contact USCIS and have it canceled because of the pending I-360. But in this case, if it's tomorrow, you need to show up with your I-360 receipt notice and your abeyance letter again, and then inform the officer what's happening. All right, going through questions. Okay, it's May 18th, so it's right around the corner. So see if you can call them, see if you can get a second tier officer, and see what can be done. But you may have to go in to make sure there's no miscommunication, make sure they don't put you as a no-show and then deny your I-45. If I file my I-751 and need to refile to FAWA, do I have to repay USCIS? You filed an I-751 with a waiver, a VAWA waiver, you don't pay a fee for that. You just have to supplement the application. Will everybody waiting for decisions receive fingerprints again? No. They're gonna use the fingerprints that they have. Maybe some people might get notices depending on whether they can reuse the fingerprints, but everybody's they're just it's just gonna be sent back. The same fingerprints they collected are gonna be used for the expanded FBI background check. Nursepreneur, you're welcome. All the best. Do I need an attorney to cancel? I would say in this time, having an attorney is going to be the best thing. Yes, if you can get an attorney on board, do it. Is it required? I don't ever want to give you the impression that you must, but I say it's basically right now to navigate this system, you having an attorney is going to be the best thing. And I would go as far as to say not having an attorney is basically putting yourself at risk. What's a straightforward N400 case? What does a straightforward N400 case look like? N400 is naturalization. So a straightforward case is going to be one where they meet all the requirements. So they meet the time requirements of 5 years, generally 3 years if they're a U.S. citizen. They meet good moral character. So they meet all the requirements for having good moral character. Nothing in their background indicates otherwise. They have continuous residence and physical presence in the United States, so they've never been outside of the United States for more than 6 months. So those are going to be the main requirements. And then you also, right now, because of the more complicated naturalization requirements, now they're doing neighborhood checks. So they can go to your workplace, they can go to your neighborhood, your neighbors, and talk to your neighbors about you. So you can be proactive by putting in reference letters, character letters from your community, from your friends, family, community leaders, church leaders, if you do church, or if you're in organizations, clubs, things like that, to give the officer a picture of who you are. And sometimes that can mitigate the neighborhood check that the officers have the right to do. All right, let me check for more questions on Instagram. Through a visa at the embassy, or they have to file an overseas parole. So, oh, thank you so much, Angel. I appreciate that. Yep. So the phone number is, if you go to the link in the profile, you can go to the website. You can also see the number on my videos or in the caption. So it's there. Everything is on hold. It's really frustrating. I'm the sponsor of my husband's daughter, but his country's ban paused. Her visa is approved, waiting a consular appointment. Yes, and everything is on hold right now. It's really frustrating. But what I say, don't give up, because the pause does not mean that you're going to be denied. I'm going to put my number in the comments on Instagram. So, and then on TikTok, if you scroll to the top of the comment section, you'll see the phone number there. So it's 405-4889. Okay. All right, I'm under immigration lawyer in the comment section. So looking for more questions, put those questions in the comments. And Facebook, YouTube, I am going to work to fix this. Yeah, so exactly. It is. So right now we have an individual that will do a more detailed evaluation. So that's the thing. If you call now, you have two options now. So one option is, if you want to get help right away, we have our director of case strategy that will do a detailed evaluation, and I'm much sooner, because I'm getting booked out right now. I'm booked into June. However, this person that we have who does the evaluations. She will talk to you in detail, see what your options are, and if your options are very complicated, you can still book time with me if she cannot resolve it. But it's a way for us to get to individuals faster, and it is right now, it is free of cost, that free initial evaluation. So give us a call and she'll walk you through it, get her book, and she is also being booked out very quickly. So definitely we have that. That is right. It's not a scam, just in case. Um, so we have that option right now. Thanks so much for the love. I appreciate it. A person is renewing their permanent green card and has a prior 13-year felony. Could they be deported? It's possible if the felony amounts to a deportable offense. Anytime you have criminal offenses, and I would say not even felony, misdemeanors as well, you need to make sure that you get it evaluated as to whether it makes you deportable, because going in for a green card interview could be actually detained and then deported. So important to get that checked. From your filing of VAWA, how long after receiving VAWA receipt would you get your prima facie? So anywhere from 3 to 6 months, the prima facie, but keep in mind, these are estimates. What's the number for the free appointment? Now this is a free initial evaluation. It's not, you don't get legal advice there. But what we do is our director of case strategy can talk to you, really sift through whether you qualify, and then we as the attorneys here at the firm will take it over from her, should you qualify. But it's a way for our team to get to work on your case faster, just because. And then I look at, if I have to, I'll talk to you about more complex issues, and definitely if it's your preference, you can schedule with me to get legal advice. But it's a way for us to get to your case faster. Even if they had it renewed before and haven't had any issues, he's been here since 1990. Get it checked. It doesn't really matter. Now, did he disclose the felony during the green card process, and was he approved even after disclosure, then that would be different. But if the felony happened after getting the green card, be very wary right now. People are being arrested for offenses that happened years ago. Right now, they're being detained and then put up for deportation. So talk to the best thing you can do is talk to us, and we can do an evaluation. So we usually have to do a check and then look at the immigration consequences of the criminal conduct, and then we can advise from there. Trying to bring a fiance over from Laos, filed the K1 paperwork, but then Laos got banned. Any suggestion? I would have to look to see if Laos is, because some visas are, no, keep in mind, banned, being on the 39 banned list does not necessarily mean that you're banned all across the board. It might be a partial ban. It might be some visas. So the K1, I would have to check to see if the K1 is one of those visas in Laos. Now, even if the K1 visa is one of the visas, here's what I say. Make sure that you move forward with process, applying, and their process. If they still ask you for documents, provide it. Request for evidence, provide it. Still move forward. You have a master hearing a few days from now. Any hopes? Absolutely, there's hope. Keep in mind that the master hearing is the first hearing of a process. In immigration court, you have a minimum of 2 hearings. You have the master calendar hearing, and that's where you go and you talk to them about, you talk to the judge about your defenses, you answer to the charges, and then the charges for deportation, and then you raise your defenses. and then the judge then looks out at the calendar and determines, okay, when is going to be the next date for an individual hearing. Now, sometimes what has been happening for us is our clients qualify for relief. So they may qualify for the T visa, they may qualify for VAWA, and so they have a pending process. And so they do consider the judge, right now, the judge in those cases does consider that, and they may say, okay, we're going to do a check-in court date 6 months from now to see where you are on this, or they put it out to maybe a year or 2 years, the individual hearing, to give time for that relief to be adjudicated and then to come to the court and be able to get their case terminated based on a possible approved relief. Thanks so much, Pinky. I appreciate that. And thanks for being a long-time watcher as well. You filed for VAWA. So do you have an attorney? If you don't have an attorney, you need to get one. VAWA is a defense to, VAWA cancellation of removal is a defense to deportation. So just make sure you have an attorney that can defend you there, and know that the master hearing is the first hearing, but you will have time to prepare for the individual hearing. Now, one thing I do want to talk about when it comes to immigration court is it feels like the end of the road, but it's actually not. You should look at it as the last chance to be able to defend yourself against deportation. And there are even options available in immigration court that is not available anywhere else in the process. For example, cancellation of removal, 42B. Cancellation of removal, where if you've been here for 10 years or more and you were even undocumented and you have good moral character and you have certain U.S. citizen or permanent resident relatives who will face extreme hardship, you will then you have a shot at getting your deportation canceled and instead getting your green card. So the judge can grant that. You can also do adjustment of status in some cases before the judge. So don't give up hope, but make sure that you have an attorney. All right. Okay, guys, I'm going to head out for the night. So tomorrow I'm going to be on, and hopefully over the weekend. Next week is going to be a busy week, and I know I've been on a roll, but next week is going to be busy. So I just want to prepare you if you're here with me all the time. Next week I may not be on as often as I have been, but I'm going to aim to be back the following week. So next week I may not be on, but keep in mind, videos still follow me, like, subscribe, hit the notification bell, because you're going to be seeing new videos, new information wherever we have to give you updates. But I just want to give you that information ahead of time that next week is I may not be on, but that does not mean I'll be gone forever. It just means just next week. All right. Have a great night, everybody. And I will see you tomorrow. And I'm going to work to come on hopefully over the weekend too, so I can make up for some time that will be missed next week. Have a good one. Have a good night. And remember, call us, talk to us. We have a free initial evaluation. I'm excited about that because we want to help as many people as possible. Take advantage of that. If you, even after the initial evaluation, you still want to talk to me, we can still schedule time to talk to me, but we need to get people to qualify, make sure we can find people that can qualify for relief and get them started ASAP. So that's what our team is working on now. Have a good night. Bye-bye. Good night on Facebook and YouTube. Hopefully I can fix the issue, and we'll be back on track over the weekend.